Thank you for joining us for tonight's program on how the judiciary protects your vote. I'm Ruth Quint, and I'm one of the co-presidents here at the League of Women Voters of Greater Pittsburgh. The League of Women Voters is a nonpartisan organization that is dedicated to defending democracy by empowering voters. During this and every election season, we prepare nonpartisan information for voters about their ballots, their candidates, and their voting rights. We invite you to find this information both at Vote 411, the nationwide voter guide site put out by the League of Women Voters of the United States, and at our own local Pittsburgh website. And I'll put both of those links in the chat. If you would like to receive announcements about future programs and other resources, please visit our website and use the Join the Mailing List button, or better yet, the Join Us button to get on our mailing list. We are delighted to be partnering once again with Pennsylvanians for Modern Courts in sponsoring tonight's program. Now I'll hand the program over to their executive director, Debbie Gross, who will introduce tonight's speakers.
Thanks, Ruth. So thank you for having us once again. We love our partnership with the League. PMC is also a nonpartisan, nonprofit. And so we have partnered with the League on having many different kinds of programs about the judiciary. And so we actually had a first part, I'll say, to this program before the primary about the role of the judiciary in elections. And now as we get closer to the general, we thought it would again be wise to have another program the other was more focused on petitions and what happened before even the primary. So now we're going to talk about the general. So I have some amazing, really truly appreciate their joining us, presenters for this program. We have Mimi McKenzie, who is the legal director for Public Interest Law Center. Public Interest Law Center is a nonpartisan nonprofit that does amazing work. It is high impact litigation, such as like class action litigation, that impacts communities facing discrimination, inequality, and poverty. You probably have seen Mimi being quoted recently, and she'll talk to you about that. But she's been at she's really the first official legal director of Public Interest Law Center, has been there since 2017, and it has done remarkable work for the Public Interest Law Center. We also have Justice Cynthia Baldwin joining us. She is a former Pennsylvania Supreme Court Justice. She's hopefully familiar to many of you in Pittsburgh because she sat on the Allegheny Court of Common Pleas for 16 years before she was appointed by Governor Rendell to the Pennsylvania Supreme Court. She too has been a staunch advocate for PMC, and we have fortunately had the good fortune, I say, of partnering with Justice Baldwin on many of our programs. So I want to thank both of you for joining us. And I'm going to share the PowerPoint, but before I do, if people have any questions, put them in the chat. We're going to try to get to them. We may not answer them right away because they could be answered later on in the program, but we will try to make sure that we get to your questions. So thank you very much. Now let me figure out how to do this. Okay. All right. And from the beginning, all right, we're at the beginning. It didn't really talk about PMC, but I know we've spoken to you. So we really teach about the court system. It's very important. People don't realize the importance of our judiciary. And so this is part of our programming. And so we are going to talk about the right to vote. Justice Baldwin.
Okay, first, let me thank PMC and the League of Women Voters for sponsoring this program. It certainly is a timely program. I'm going to start out with 3 quotes that mean a lot to me, and I'm hoping that you'll think about them as we go through the program. The first quote was by Thomas Jefferson, who said, "We do not have government by the majority. We have government by the majority who participate." The second quote is from Lyndon Baines Johnson, Voting is the first duty of democracy. And the third is for Arundhati Roy, and that is, the crisis of modern democracy is a profound one. Free elections, a free press, and an independent judiciary mean little when the free market has reduced them to commodities available on sale to the highest bidder. So let's think about those as we go through this program on the judiciary and elections. There are two parts to what we do in the judiciary, because as you know, we have a federal judiciary and we have a state judiciary. We call the federal judiciary Article 3 courts because they're in Article 3 of the US Constitution. The founders believed that the independence of judges would protect their ability to uphold the law no matter how unpopular. So our district court and our Third Circuit Court of Appeals are Article 3 courts. Now, Article 5 of the Pennsylvania Constitution establishes a unified judicial system, including the Supreme Court, the state Supreme Court, the Superior Court, the Commonwealth Court, the Courts of Common Pleas, community courts, and municipal courts in the city of Philadelphia. The Commonwealth Court is one of Pennsylvania's two intermediate appellate courts, and it's our youngest court. The Commonwealth Court was established in 1968. It is responsible for matters, as you can see on the quote, yes, I think it's going to be coming up, that it is responsible for matters involving state and local governments, regulatory agencies, and also acts as a trial court when lawsuits are filed by the Commonwealth or against the Commonwealth. The Superior Court, which is the other intermediate appellate court, has jurisdiction over most civil and criminal matters. The election cases you'll see are in the Commonwealth Court. Many of them go to the Commonwealth Court. Article 1, Section 2 of the U.S. Constitution gives the states jurisdiction over voter qualifications and the time, places, and manner for federal elections. However, Congress can, and this is a quote, by law make or alter such regulations. Article 1, Section 5 of the Pennsylvania Constitution states, elections shall be free and equal, and no power, civil or military, shall at any time interfere to prevent the free exercise of the right of suffrage. The qualifications for electors are in Article 7. Now, it's interesting because I'm old enough to remember when the voting age in the United States was 21 until the 26th Amendment to the U.S. Constitution was ratified in July of 1971. That changed the voting age to 18 years of age, and it was sparked by the idea that if you're old enough to fight, you're old enough to vote. We vote by secret ballot. Contested elections by law are determined by the courts. That is the reason that the judiciary is supposed to be nonpartisan and non-political and independent. Our system relies on trust in the independence of the judiciary. It has only been within the last decade that there has been a trend to decrease voting rights, not expand voting rights. In 2019, the Pennsylvania Election Code was revised, though, to get rid of straight ticket voting, that's expanding the right, to add mail-in voting, that was expanding the right, and to fund and replace voting machines. In August of 1965, an act to enforce the 15th Amendment of the Constitution of the United States and for other purposes was passed. We know it as the Voting Rights Act. And although in 2013, in the case of Shelby County versus Holder, the Supreme Court held that states with a history of voting rights violations against people of color no longer had to seek pre-clearance in order to pass new voting changes, the act is still in force. Also important to the voting process is what we call the materiality provision. And the materiality provision has been discussed a lot these days, but it is not part of the Voting Rights Act. It is part of the Civil Rights Act of 1964. This provision states, quote, "No person acting under the color of law shall deny the right of any individual to vote in any election because of an error or omission, if such error or omission is not material in determining whether such individual is qualified." Until recently, this provision has saved the votes of many qualified voters whose votes were challenged for immaterial reasons. Recently, in the case of Pennsylvania State Conference of NAACP branches and others, including the League of Women Voters, versus the Secretary of the Commonwealth, the U.S. Court of Appeals for the Third Circuit held that the materiality provision only applies to whether an individual is qualified to vote, not to the actual vote itself. Now, this is what this means. We've heard so much about the dates on ballots, mail-in ballots, and many courts have already found that those dates are immaterial. And the Third Circuit Court said that, but that's not actually qualifying an individual to vote. So that's an interesting case. The other issue regarding the materiality provision is who can enforce the provision. The materiality provision expressly provides for the Attorney General to enforce that provision, and it's silent as to private enforcement. Again, the Court of Appeals for the Third Circuit addressed this in the case of Migliore versus Cohen in 2022. They held that the registered voters of Pennsylvania did have a private right of action to enforce the materiality provision, and that the dating provisions are immaterial to a voter's qualifications and eligibility. They remanded that case back to the district court with directions that the undated ballots be counted, as we all know. But as you know, there have been a rash of voting rights cases during this election cycle. And I know a person who's been involved in many of those cases. We have the right person to talk about them because Mimi McKenzie, who is legal director for the Public Interest Law Center, has been involved in many of them. Mimi, I'm going to turn it over to you at this point.
Thanks so much, Justice Baldwin. Good evening, everyone. It's really a pleasure to be here and to see so many people interested in this issue. So at the Public Interest Law Center, as Debbie mentioned, we advance the civil, social, and economic rights of individuals facing discrimination, inequality, and poverty. And we essentially work in 6 spaces. For the most part, we focus on the tangible things that all of us need to live our lives. So public education, quality housing, a clean environment, a job that pays a living wage, access to quality health care. But the 6th area, and the area that we are spending an incredible amount of time and resources right now, is voting. And because voting really does underlie all our other rights, and it's how we ensure access to many of these other rights. I have to say from the outset, we do not do this work alone. We, in this election season, are joined at the hip with the ACLU Pennsylvania in co-counseling on these cases. And we often partner with large law firms to increase our resources as we file these cases. And we often partner with the League of Women Voters. It is always an honor and a pleasure when the League serves as one of our organizational clients in these various lawsuits. So much of the litigation that is going on right now in Pennsylvania is really related to no excuse mail-in voting. Prior to Act 77, which was passed in 2019 and the first time rolled out in May of 2020 during the pandemic, prior to that, we only had absentee voting where you had to have an excuse while you would not be able to vote at your polling place. And so Act 77 was an incredible win for voters in that it really expanded the ability to vote, and so many people take advantage of that, in particular individuals with disabilities, seniors, all sorts of people. And we saw, obviously a huge uptick then in mail-in voting in 2020 and in April 2024. So, over 30% of qualified registered voters in Pennsylvania are voting by mail. And as terrific as Act 77 was, it's not in every way a model of clarity, to say the least, which is unfortunate. We really hope that someday the General Assembly could agree to maybe clean up some of the issues around mail-in voting, which is why there's so much litigation over some of these provisions.
And I just want to ask you, we're not the only state that does this, right? And we were probably one of the latter states to the party.
Sure. Yeah, no, that's a really good point, Debbie. There are lots of states that have mail-in voting, and mail-in voting is safe and it is secure. And the incidents of fraud with mail-in voting are so few and so far in between. And yet, unfortunately, it has become a hot button, if you will, for individuals and partisan actors who are determined to decrease rather than increase access to voting. So much of the litigation that we have been filing in 2024, it all centers around mail-in votings and the fact that individuals, voters, somewhat regularly, anywhere from about 1.5% to 2%, make mistakes on their ballot packets. And there's essentially 3 mistakes that will disqualify your mail-in vote. The Pennsylvania Supreme Court has confirmed that if you forget to sign the back of your mail-in ballot envelope, your ballot cannot be counted. If you forget to date the envelope, your mail-in ballot can't be counted. If you write a wrong date, if you write the wrong year, if you write a month that is outside of the period when you could have actually signed and dated this ballot, your ballot won't count. And if you forget your secrecy envelope, your ballot will not be counted. And that is the source of much of the litigation that has been taking place over the last 4 years. And I think there's a couple of things to keep in mind about these 3 disqualifying errors, if you will. In particular, the date on the back of the mail-in packet, it has been confirmed by all 67 counties in prior litigation. In the NAACP versus Schmidt case, which was a follow-on case from the Migliore case that Justice Baldwin mentioned, that this date on the back of your mail ballot envelope is not used for anything. It is superfluous. It is a vestige from a prior era when the date of mailing was significant, but now under the election code, the only date that matters for purposes of your mail-in ballot is the date that the ballot is received. And there is a very secure, uniform system in place in Pennsylvania for confirming the date of receipt. So when a board of elections in any of the 67 counties mails out well, first of all, you apply for your mail-in ballot. When you apply for your ballot, at that point, the Board of Elections confirms that you're a valid registered voter in Pennsylvania, you're a qualified voter. When they send out your mail ballot, there is a barcode on the outside envelope of every ballot, and they scan that into the state uniform system, the SURE system, and that shows that the ballot was mailed out. When the ballot comes back in, the election office stamps that ballot. That is the date, that's the timely receipt date, and they scan it back into the SURE system. So the actual handwritten date is not used for any purpose whatsoever. But nevertheless, our election code says that voters shall sign and date, and the courts have held that shall means shall. And so if it's missing that date or it has an incorrect date, it can't count under the election code. So this has been litigated in a variety of cases. As Justice Baldwin mentioned, it was litigated under the Federal Civil Rights Act materiality provision. And unfortunately, that litigation has not been successful. And so in May of this year, the Public Interest Law Center, along with the ACLU of Pennsylvania, brought a case on behalf of a large number of organizations. It's this case BPEP versus Schmidt. And for the first time, we challenged the practice of not counting mail-in ballots because they have a missing or incorrect date as a violation of the Pennsylvania Constitution's Free and Equal Elections Clause, which is Article 1, Section 5 of the Pennsylvania Constitution. We filed that case in Commonwealth Court because we brought the case against the Secretary of State, Secretary Schmidt. And we also named the 2 largest counties where our clients were most active. So we brought it against Philadelphia County Board of Elections and the Allegheny County Board of Elections. We opted not to bring it against all 67 counties for a lot of logistical reasons that I'm sure you can imagine. Anytime you have more than a couple of lawyers in a case, things have a tendency to drag, to say the least. Anyway, we brought that case in May in the Commonwealth Court. and we prevailed in the Commonwealth Court. The Commonwealth Court agreed with us. A majority of the justices agreed that to not count these votes when that date is superfluous is a violation of the fundamental right to vote that is guaranteed in the Pennsylvania Constitution. At the same time that we filed that case, the political parties intervened in the case. The Pennsylvania Democratic Party and the DNC intervened in the case, as did the Pennsylvania Republican Party and the RNC. The Secretary of State actually agrees with our position, as do the boards of election in Philadelphia and Allegheny County. So the RNC and the Pennsylvania Republican Party appealed the decision to the Pennsylvania Supreme Court. And the Pennsylvania Supreme Court, without addressing the merits of whether or not it's a violation of the Pennsylvania Constitution to not count these votes, they vacated the decision of the Pennsylvania Commonwealth Court on procedural grounds. And among other things, they held, you need to have all 67 counties here, and that the Commonwealth, it's not enough to be in Commonwealth Court because the Secretary of State's not an indispensable party. And so that presented some challenges, to say the least. And one option that we tried to avail ourselves of, and I think there's a slide on this. So normally when you file a lawsuit, you first go to the trial court and then you make your way up from the trial court to the appellate court. But here in Pennsylvania, the Pennsylvania Supreme Court does have the ability to take up issues of significant public importance under their King's Bench authority or their writ of extraordinary jurisdiction. And essentially what that means is if the Pennsylvania Supreme Court thinks that a case is important enough, it can bypass the normal trial court and appellate court and take up a case itself. And it's pretty rare that it exercises this extraordinary jurisdiction or this King's Bench power, but it does periodically happen, particularly in election and voting related cases. So just to give you an example, my, I think, favorite lawsuit of all time, the League of Women Voters versus the Commonwealth, where the Public Interest Law Center challenged our congressional gerrymandered map. That was a case that the Pennsylvania Supreme Court agreed to hear in 2017 under its extraordinary jurisdiction powers, because the only way to get a decision in time before the next election was for the court to expedite everything. So it's a unique feature of the Pennsylvania Supreme Court, and one that we again tried to take advantage of on this whole issue about should mail-in ballots that have a missing or incorrect date count or not count when that date is superfluous. So we filed for extraordinary jurisdiction, naming all 67 counties, but the court declined to take up extraordinary jurisdiction. As you can imagine, this is a really important issue, this whole dating issue for voters around the Commonwealth, because half of all the mistakes of this 1.5 to 2% of mistakes made on mail-in ballots are mistakes about the date. So it is the most common mistake that voters are making. You know, it's an important issue to get a decision on the merits on, but
And so, and I'm just gonna interrupt you one more time. Amy,
yeah,
because
no, interrupt away.
one of the corrections, right, is that they now have put the year, right, on the, my understanding is that in the mail-in ballot, when it's printed, the year is now there because many people put their birth date on as the date as opposed to the date of signing.
Yeah, that's absolutely right. You know, the Department of State is really interested in making sure that that voting is as straightforward and as and that the instructions are as clear as possible. You know, but the reality is we meet voters all the time around the Commonwealth who have a human moment, if you will, and when they're filling out that ballot, you know, I know myself, I've done this sometimes when I write a check. For some reason, I write 2023, even though I know it's 2024. And so sometimes you'll see that type of mistake. Sometimes there's actually confusion because people are using the European method of dating. And even though those ballots should count, that's not always been the case. And then, of course, I think a lot of people are so used to when you fill out a form, you need to put your birth date, that it's almost sort of an automatic, if you will. So that's correct that in an effort to try and reduce the number of these what should be inconsequential mistakes that have big consequences when it comes to voting, the Department of State now has the entire year written out, so people will at least not make that mistake. But that is a good segue into, we do still have one more vehicle, if you will, one more lawsuit that is still pending in the state courts around this dating issue. And this is the case Baxter versus the Philadelphia Board of Elections. So in September, there was a very little known special election happening in Philadelphia around a state representative office. And it wasn't even a contested election. About 1% though of the voters who voted in that special election nevertheless still got caught up in mistakes on their mail-in ballot. And we brought this challenge on behalf of 2 voters who had simply forgotten to put the date on their ballot. They signed their ballots, they put them in their they put their ballots in the secrecy envelope, they sealed it up, they signed the back of the envelope, but they neglected to write the date. And so under that earlier decision I mentioned to you, those votes couldn't count. There is a process for challenging the failure to count a mail-in ballot at the canvass under 3157 of the election code. And so we ran into court. You have to bring these things within 2 days. So we ran into court and we filed this lawsuit. And we had to bring this in the Philadelphia Court of Common Pleas. We actually couldn't bring it in Commonwealth Court because we were only suing the local board of elections. And so we filed that case in the Philadelphia Court of Common Pleas. And again, we raised this issue that not counting a ballot that is missing a date violates Article 1, Section 5 of the Pennsylvania Constitution. The judge in the Philadelphia Court of Common Pleas agreed with us and said to the Philadelphia Board of Elections, you need to count these individuals' ballots. In fact, you need to count all of the individual ballots where folks made a dating mistake. Once again, the Republican National Committee had intervened in this case, and they filed an appeal to the Commonwealth Court. We very quickly briefed these issues, and the case is now pending in the Commonwealth Court. The exact same issue that we had litigated back in May. We're back again, and we're waiting for a decision from the Commonwealth Court.
And Mimi, just
Mimi?
procedural,
Go
do you
ahead.
want to, like, that you briefed it very quickly. Do you want to explain that a little bit? Because there was an order, right, as opposed to the normal 30 days, that kind of thing.
Sure. So as it stands, you know, in a typical lawsuit, if you lose a lawsuit at the trial court level, you would have 30 days to file an appeal. When there are issues arising under the election code, that time is shortened, and normally it's 10 days. But the courts have recognized the seriousness of all of these issues. And we are now on a, and I think you have a slide on this, Debbie. We're on a 3-day.
Right.
So if you lose a case, you now have 3 days to file your appeal. And then you have, I think it's 24 hours, maybe it's 48. I'm not bragging, but since we've won all of our cases, we're always the appellee, not the appellant. But they have, I believe, 24 or 48 hours to file their brief, the appellant brief. And then we have 48 hours to respond to that. So
Mimi?
it is no exaggeration that we are all working around the clock.
There it is.
Had multiple, 24 hours. Oh, I'm sorry, it's 24 and 24. We did have 48 on some of the cases. So we are literally working around the clock on these cases. There's maybe a window between about 3 a.m. and 4 a.m. where no one's touching the brief. But other than that, there is a lawyer working on it. And
I'm just going to add, this is really remarkable that you guys are working so hard, because everybody needs to know that, like, lawyers here are public interest lawyers. They're not I'm going to give an advertisement. They're not the best paid. They're public interest lawyers, and they're, you know, as opposed to working at a big firm where you make a lot of money and you're expected to work around the clock. So here they're just doing a yeoman's job. Sorry, Mimi.
Mimi, I have a question. The question is, would this be a good place to talk about notice and cure and provisional ballots too? Because a lot of times I know that it's in the paper a lot about notice and cure, and I get this question a lot, that how, you know, nobody contacted me, and so, you know, could I fix it? And I think people need to know that first, all 67 counties are not notice and cure counties. So you have to be, and I'm not sure of this, Mimi, you probably know better. I've heard the number 36.
Yeah, that's correct. So in Pennsylvania, we have a very decentralized system of elections, and each county board of elections, while they all have to comply with state and federal law, there is a fair amount of leeway for some of these election administration issues. Now, the ACLU, our partners, have done a very terrific job of serving right to know requests on all the county boards of election so that we could get as complete a picture as possible as to which counties are allowing voters to fix some of these disqualifying errors on their mail-in ballots. So the date issue that I've been talking about, that if we are ultimately successful in that, that doesn't require any notice and cure, right? That just says those ballots need to count under the Pennsylvania Constitution, and it doesn't require the voter to do anything. But that whether that gets decided in time for the election remains to be seen. And it doesn't address the issue of voters who forget to sign the back of their mail-in ballot or sign in the wrong place, or voters who forget their secrecy envelope. And that's where this notice and cure comes into play. The courts have held in prior litigation, starting back in 2020, that the election code does not require notice and cure. And it also doesn't prohibit it. And so that's how we've ended up in this situation where different counties have different practices. And based on the terrific work done by the ACLU, the majority, although not by a lot, of counties will give voters notice and will allow a voter to come in ahead of time to the election office and fix the problem. And they have different ways of doing that. In some situations, in some counties, they'll let the voter, if they forgot to sign, they'll let them sign the back of the envelope. In some cases, they will, like in the case of a lot of the boards of election actually have machinery that can tell if a secrecy envelope is missing by weight and by dimensions. They'll destroy the ballot, give the voter a new ballot, let them fill it out, and use the secrecy envelope appropriately. So there are a lot of counties that provide that notice and curing opportunity, and they provided in the notice in different ways. As I mentioned to you, when a mail ballot comes back to a board of elections, it gets scanned into the SURE system. And the SURE system technology has continued to evolve. And at this point, through the SURE system, a county board of elections can notify a voter who has an email on file that there's a problem with their ballot. And they can notify the voter, depending on what kind of cure or not cure county they're in, they can tell the voter what they can do about that problem. But, you know, there are counties that are not providing for notice and cure. And so we have two different lawsuits that we're awaiting decisions on around these issues around notice and cure. The lawsuit around notice is this case called Center for Coalfield Justice versus the Washington County Board of Elections. And this case arose after the April primary, or actually we got wind of it during the April primary, where the Washington County Board of Elections prior to 2024 was allowing notice and cure. And they were not only sending voters an email through the SURE system if there was a problem. If a voter didn't have an email on file, they would at least make one phone call to the voter. And if a voter called the Board of Elections and said, hey, I returned my ballot, is everything okay on the envelope? They would tell the voter if it was okay or not okay. But they had a change in composition of the Board of Elections, And they decided in 2024, they were no longer going to allow any type of notice and cure. And so what started happening was mail ballots would be returned. And when a mail ballot is returned, you can tell right away if it has a problem because it's right there on the back of the envelope. And so the Board of Elections or the election workers were instructed to stamp the ballot with the date that it's returned, scan it into the Shore system, but don't click on one of those codes that would alert the voter that the date was wrong or that there was a missing signature. Nevertheless, they segregated those ballots and they knew those ballots weren't going to count, but they didn't tell the voters that they weren't going to count. And we brought a claim on behalf of both individual voters and 2 organizations that to not tell a voter that there is a problem with their mail-in ballot violates procedural due process under the Pennsylvania Constitution. That if you're going to deny a voter the right to vote, you need to give them notice, and that there's a really simple way to give notice. All you need to do is click on the proper code in the Shore system so that an email goes out to the voters. Because either way, you have to click on a code. And so the question was, what they were doing is they were clicking on a code that just said received, but if they had clicked on the code that said received, you're missing a date or you're missing a signature, the voter would have gotten notice. Now you might be asking, well, what good does notice do if there's no cure? And that's the subject of our other related lawsuit, which is Genzer versus the Butler County Board of Elections. In any event, just to close out the loop on the procedural due process case, though, the CCJ case, we won in the Court of Common Pleas in Washington County. Again, the RNC intervened in the litigation and they appealed it to the Commonwealth Court. We won again in Commonwealth Court. And then they asked the Pennsylvania Supreme Court to take up the issue on what's called a la carte. The Pennsylvania Supreme Court agreed to do that. The issues are now fully briefed, and we're any day now expecting a decision on this notice issue. Hand in hand with this notice issue is this case called Genzer versus the Butler County Board of Elections. And this case has to do with voting and counting what are called provisional ballots. So a voter who makes a mistake on their mail-in ballot, even if a county does not allow curing, doesn't allow them to come into the office ahead of time and fix a problem, that mail-in vote is not going to count. And we brought a lawsuit asserting that nevertheless, a voter always has the right on election day to go to their polling place and cast what's called a provisional ballot. And that when you make a mistake on your mail-in ballot, that ballot is never going to count. And so you still have this last chance, if you will, to salvage your right to vote by voting a provisional ballot.
And there are other reasons you can vote a provisional ballot.
Yeah,
like
do you want to know that would, yes.
Yeah.
Do you want to talk about that, Justice Baldwin?
Well, I know if you are supposed to have ID and you don't have ID, you can vote a provisional ballot and then they can check that. I think that also if you're not on, if that's not your polling place or you're not on the list in that polling place, you can vote a provisional ballot. then. I think there were a couple of other reasons too, but those are the ones.
Yeah, those are the,
I know the big one. If your eligibility is challenged, right, by the official there, you can vote a provisional ballot.
And the only thing I want to say to add to this is this is important, right? People shouldn't be, I'm not going to use the term, but shouldn't be pushed or bullied to think that they can walk away, but they should insist that, I want to fill out a provisional ballot.
Right, right. That it's very important because a lot of times people feel that the officials there know everything about it, and so they don't push for a provisional ballot. And it's really important. You can vote a provisional ballot, and like I said, if you make a mistake on your mail-in and those other 3 reasons, ask for that provisional ballot.
yeah, and just in case anyone's not familiar with a provisional ballot, so normally when you go to your polling place, you vote on the machine. You definitely want to vote on the machine if if you're eligible and qualified, because then your vote is automatically going to count. Provisional ballots are paper ballots that you fill out, and then those get reviewed, and decisions are made whether or not provisional ballots should count. That happens on the back end a couple of days after the election. And
I see that someone has asked a question about the notice and cure graphic, because Mimi, you've gone through that in great detail, and they want to know what the gray counties stand for on the graphic. I don't have the graphic in front.
I think the gray counties stand for the counties that you cannot cure.
no, I think they're the
Get it?
ones that did not respond to
They
the,
respond
yeah.
to the right to know. Yeah.
Yeah, so we're not sure what is happening in those counties. Because the other thing is that counties, they, as I mentioned with the Washington County Board of Elections, counties, as the makeup of their county commissioners change, sometimes they change their process for notice and cure. So yeah, that's my understanding for the gray.
Okay, so you are at Gensler, I think. I'll go back to Gensler. Hold on. There we go. Gensler. Okay.
So, so this is an issue that has been around for a couple of election cycles, this whole issue around provisional ballots. So I'll just give you a little bit of background. For example, in May 2023, after the primary in Delaware County, there were 2 voters who, no, there were actually more. There were about 6 voters who we represented who made one of these disqualifying errors on their mail-in ballots, and the Delaware County Board of Elections, they can't count those ballots, and that is Pennsylvania law. But these individuals, they had been notified that they made an error, so they went and voted provisional ballots. And the Delaware County Board of Elections said, well, we can't count those either. So yeah, we can't count any of your votes. Either of your votes, I guess I should say. So we challenged that under that appellate provision that I mentioned, 3157 in the election code. And the Delaware County Court of Common Pleas agreed with us. You have to count these provisional ballots. And the Delaware County Board of Elections didn't appeal that decision. So maybe Justice Baldwin, you can explain why when you only have a decision from the local Court of Common Pleas, the implications or lack of implications of that
Right.
decision.
Well, the only implication is that the fact is that it wasn't appealed, and since it wasn't appealed, it will stand. But the fact is that the other thing I wanted to say about this, about the Court of Common Pleas, when we're talking about the provisional ballots too, is that we should remember that there's always a judge on duty
Right.
in the counties, so that if you're getting a lot of pushback, if you're having a lot of problems, yeah, and I know that it's more work, but you can go to your Court of Common Pleas. There's a judge that's on duty from the time that the polls open until I believe 10 o'clock. There's a judge on duty, and if you're getting a lot of pushback and there are problems, and I see that the League of Women Voters also already put up their "Don't Leave Without Voting" provisional ballot flyer. But if you're getting that, you can go down to the Court of Common Pleas and get an order. The judge will give you an order that you can vote your provisional ballot.
So when the Delaware County Board of Elections didn't appeal that decision only had binding effect in Delaware County, but did not have a statewide effect.
That's true. Yes.
So we've been paying attention to this issue for a while. And then the same issue happened in the primary in Butler County. In this situation, Butler County had a little bit of an unusual process where if a voter made a mistake on the date or the signature, they would count the provisional ballot. But if they made a mistake and forgot to put the ballot in a secrecy envelope, they wouldn't count the provisional ballot. So we brought there were two voters both of whom forgot their secrecy envelopes. And they got notice that they forgot their secrecy envelope because they have special machinery in Butler County that really with almost 100% certainty can predict whether or not you have your secrecy envelope. They went and voted a provisional ballot. And then when it came time to canvass the mail-in ballots, and the ballot is missing a secrecy envelope, that ballot cannot count. And so
Amy, I'm just going to interrupt you one moment, because canvas is sort of a technical term. So do you just want to explain what that is?
right. So when you've probably heard some discussion around this both in 2020 and again now in 2024, that with mail-in ballots, the boards of election aren't allowed to start counting or canvassing those ballots until after the polls close on election day. That's just the rule in Pennsylvania. It's not the rule in other states in the country that have mail-in balloting, but it's why, for example, in 2020, it took quite a few days before we knew which candidate was carrying Pennsylvania, because they had to count all of those votes. So the situation then in Butler County was we brought a lawsuit. Again, we had to bring it in the Court of Common Pleas because we were only naming the County Board of Elections. Actually, that case we brought in, I guess it would have been in late April. And we actually lost in the Court of Common Pleas. So we appealed to the Commonwealth Court. And then the Commonwealth Court ruled in favor of the voters and said, no, when the mail-in ballot is not going to count because of these disqualifying errors, and the voter has cast a provisional ballot, the provisional ballot should count. The whole point being that, there are very safe, secure systems in place to make sure that no voter gets to vote more than once, that only one ballot counts, but that it shouldn't be 0 ballots count. So the Court of Common Pleas ruled in favor of the voters. Again, the RNC had intervened in that case and sought review from the Pennsylvania Supreme Court. The Pennsylvania Supreme Court had agreed to take up the issues. We briefed all of the issues. Just last week, the Pennsylvania Supreme Court affirmed the decision by the Commonwealth Court that yes, when a voter makes a disqualifying mistake on their mail-in ballot and they cast a provisional ballot, that ballot should count. On Friday, the RNC asked the Pennsylvania Supreme Court to stay that decision. The Pennsylvania Supreme Court on Friday afternoon told us we had to file our response to their stay by Sunday at noon. So it was a fun weekend. And then just today, the Pennsylvania Supreme Court denied that stay. And also today, the RNC has now gone to the U.S. Supreme Court, and they're trying to seek a stay in the U.S. Supreme Court. So that's where that issue sits at the moment. We have been ordered by the U.S. Supreme Court to file our response to the stay on behalf of the voters. We need to file our response by 4 o'clock on Wednesday. So
now people know why you're so busy all the time, Mimi. Another thing,
I work with an amazing team, both at the Law Center and ACLU. And on this particular case, the firm Deckert, which is a large nationwide, actually global law firm.
So I didn't even know about that Supreme Court.
Yeah, that was just filed
Wow.
this afternoon.
And the other thing about ballot counting, though, is that because Pennsylvania doesn't allow the ballots to be counted until the close, people wonder, or issues are raised, that something's going on because it's taking us so long to count the ballots. And that issue doesn't take place in the states that allow the ballots to be counted prior to the close.
Right.
Yeah, misinformation and disinformation loves a vacuum. So, one of the things that elected representatives have tried to fix in the Pennsylvania election code is to allow county boards of election to start that process earlier. Because as we mentioned, not every state has a rule like that. But it's why we don't know, which way Pennsylvania is going until, several days after the election. And obviously before 2020, we always knew, but that's because we didn't have millions of voters voting by no excuse mail-in voting. So,
and the other thing is that the legislature has there are various legislators who have proposed corrections.
absolutely.
And this has not been intentionally, really. They can't seem to agree.
Yeah, which is unfortunate. I see that there's some questions in the chat. Should we take some of
Well, one
those?
of them has to do with certification refusal or delay, and I know that this was on your slide, so I didn't know if you wanted to address that.
Sure, or I guess while we're just closing out the loop on these mail-in ballot issues, I see there is a question about Julie has asked what percentage of mail ballots are disqualified and not counted in other states like Colorado and Washington. And I would really like to know the answer to that. Our organization has not had time, frankly, to dig into that, but I think that would be a terrific communications project for someone to take on, maybe even the league or some other organization, because you certainly, there's issues around mail-in voting in some of the other states too, but Pennsylvania, it's a particularly hot issue. Yeah, and I also want to just address this issue that Ruth has raised, that there's rumors, if you will, that individuals and groups are challenging mail-in votes based on information in the National Change of Address database. And we are starting to hear reports about that. It's not clear at this point how widespread it is, but there have been a couple of counties where there are these uniform, kind of identical challenges being filed with the boards of election. And essentially what they're doing is they're looking at two different sets of data. One is they're looking at all the people who have put in a change of address in the National Change of Address database to have their mail forwarded. And then they're looking in the SURE system as to like who has been returning ballots. And, anyone with more skill than me when it comes to writing a software program that would compare those, you could essentially spit out a list of voters who perhaps, but just as likely not, are no longer Pennsylvania residents, and then challenge a mail-in ballot that way. And the reason that's really not an effective way to challenge someone's qualifications to vote in Pennsylvania is that just because someone puts in a mail forwarding change of address in that database does not show an intent to change their residence or to vote somewhere else, right? Like, it could be anything from
Well, I have a house in Utah and I change my address every once in a while to forward my mail. So yes.
It could be Debbie.
Yeah, there's a question there about certification of election results, and other than lawsuits and court orders, what else could?
Well, yeah. The reason why I wanted to take some of these other questions first is that they could have implications for the certification of the results, right? So if there are a lot of these outstanding challenges to mail ballots, and county boards of election determine that they have to have hearings on these challenges, that's obviously going to slow things down and could potentially delay the certification of the election, which could have all sorts of implications. We've not in Pennsylvania, this has not really been an issue in prior elections where we are at risk for not being able to certify the election by the I think it's December. You had it in your
Yeah,
Yeah, I
materials.
do have it.
Yeah.
11th, is it?
25th. Or
But
unless,
November 25th. Okay,
Oh.
yeah. But it's something I think it's something on the list of things that you at least want to be prepared for. Now there are a lot of parties besides the Public Interest Law Center and the ACLU that would have an interest in the certification being delayed. So not exactly clear what everyone's lane would be in something like that. But I think one of the issues that we're just paying attention to is to the extent that some of these earlier legal issues can slow things down and then delay the certification. So we want to be sure that these issues get cleared quickly. So if there were to be these, kind of mass improper challenges of voters' residency just based simply on the change of address database, we would consider what types of litigation strategies we could use to address that issue. Or there's provisions in the election code where voters can demand a recount. Recounts can slow down the certification of an election. So, these are the kind of issues beyond what we're already litigating that we research and we think about, and we try to game out and prepare. And we hope we never ever use any of those materials.
So Mimi, you have to go to court a lot, and people are very concerned about court stuff. I mean, they're reading a lot about what's going on in courts and how, judges are being more political. What is your view on when you're going into court? How do you feel?
That's a hard question to answer. I will say that I remain optimistic that the courts will get this right. For example, when I look at this Genzer case, that now the RNC has gone to the US Supreme Court and asked them to step in. I look at that case, and that case is, and they're using this theory that's, I don't know if anyone is familiar with this, but the independent state legislature theory. What they're trying to say is that essentially the Pennsylvania Supreme Court, by allowing these provisional ballots to be counted, has overstepped its bounds of authority. And the simple reality is it has not. The Pennsylvania Supreme Court simply did what a court is supposed to do, which is interpret the Pennsylvania election code to allow these ballots to count. It's simply a matter of interpreting state law. And I'm optimistic that the US Supreme Court will recognize that this is a perfectly appropriate judicial exercise of authority, and will deny the stay.
Yes.
I really do remain optimistic about that until proven wrong, I guess.
And I think
But you
it's
can't stay up all night writing a brief if you're not optimistic. So
I think it's really important for citizens to know how very little fraud there is, and that the most important thing is to make sure that all citizens get to vote.
Right.
That's what the court should be doing, to make assure that we do get to vote, not to assure that we don't. And I think that's how the courts.
And I think the other thing I would just mention, you know, when you like, when you look at the makeup of the courts that have been deciding these cases, they've not necessarily, they've not been like 7-0 decisions, but the breakdown has not been strictly along party lines.
Party lines, right.
And so I think that also is in some ways telling that it's not a completely partisan exercise, if you will. Like if you look at the makeup of the
Dissent.
Commonwealth Court, and just the parties that the judges were elected from, it's not necessarily playing out that one party is deciding in favor of the voters and the other party isn't. It's a little more mixed than that.
Which-
And even in
which is-
the Genzer decision,
In the
there's this-
Pennsylvania Supreme Court,
Right,
it
right.
didn't break down strictly along party
Along
lines.
party
So,
lines.
Which is why it's so important to
Right.
look at the judicial elections too, which PMC does a lot with, so that people can see candidates and know the candidates and ask the questions, because that's a really important part of this process, to know the candidates, the judicial candidates, and that's part of our duty in a democracy too.
So, all right. Well, I want to say thank you, because this was wonderful. There's definitely, there's a lot of misinformation out there, but you should know that the ABA has a democracy task force. Pennsylvania has a democracy task force. And we're talking, and there are people and there are lawyers on both sides of the spectrum, right? Participating in these democracy task forces. You also have this organization called Judge Jones's organization, Keep Our Republic. That there's just a lot of people who are concerned with safeguarding our democratic processes. So I think it's important that we keep our faith in the system. And I want to thank you both for your time, and thank you, League of Women Voters, for organizing this, and Mimi, thank you for your hard work. I am not kidding. Like, it is really and truly appreciated.
And even if it's not appreciated, you need to keep doing it, because it is so important. I mean, sometimes, I know that you may not feel that it's appreciated, but it is, what you are doing is so very important. So thank you so much for what you are doing.
No, it's like I said, we play a team sport, and
Yeah, no, I know.
we are in close contact with the League of Women Voters. You're one of our all-time favorite clients.
Right.
No, I want you to know, I have voted already. I went and I voted, and as I turned in my mail-in ballot, they looked at it and they said, "This is good. You have the date and the signature."
Right. Yep.
Yeah,
That's great.
which
Okay. All right. Well, thank you, everybody, and have a great night.